Without objection.
Thank you, Madam President. Now I would ask unanimous consent that it be in order to call up the following amendments to the Reed-Inhofe substitute amendment number 3867 as modified in the order listed, and that these be the only remaining amendments in order. 1. Cruz 4656, 2. Kane 4133, 3. Peters Portman 4799, 4. Scott of Florida 4831, 5. Marshall 4093, 6. King and Rounds 4784, 7. Hawley 4140, 8. Hassan Cornyn 4255, 9. Paul 4395, 10. Sanders 4654, 11. Daines 4236, 12. Menendez 4786, 13. Lujan Crespo 4260, 14. Lee 4793, 15. Sanders 4722, 16. Portman Shaheen 4540, 17. Menendez 4860, 18. Risch 4859, 19. Durbin Lee 3939, 20. Shaheen Collins 4584, 21. Kennedy 4660, 22. Ossoff Tillis 4802, 23. Lankford 4100, 24. Codden Wicker 3980. That the Senate vote at 10 a.m. on Thursday, December 2nd, in relation to any first-degree amendment offered in the order listed above, with 60 affirmative votes required for adoption of the above amendments in this agreement. Further, that upon disposition of the above amendments, the Senate vote on cloture on amendment number 3867 as modified upon reconsideration, and the motion to invoke cloture on H.R. 4354 be withdrawn. That if cloture is invoked upon reconsideration, the Reed Amendment number 4775 be withdrawn, and the Senate vote on the substitute as modified and as amended, if amended. That the bill be considered read a third time, and the Senate vote on passage of the bill as amended, if amended, and that there be 2 minutes for debate equally divided in the usual form prior to each vote, all without further intervening action or debate.
Is there objection?
Reserving the right to object.
The junior senator from Oklahoma.
So here's my problem. Yesterday, and I mean yesterday, Secretary of Defense released out a memorandum. The memorandum was about pay for National Guard members in the vaccine. We have National Guard members in very large numbers and percentages all around the country that have not been vaccinated at this point. Now, there's 2 sets of rules for the National Guard. One for the Air National Guard. Their deadline for the vaccination is tomorrow. Now, remember, this memorandum came out yesterday. Their deadline for the vaccination is tomorrow, December the 2nd. For the Army National Guard, their deadline is the 30th of June. So 2 sets of rules for the Air National Guard and for the Army National Guard. Completely different, 6 months apart plus. For the Air National Guard, this word came out yesterday with this statement: no Department of Defense funding may be allocated for payment of duties performed under Title 32 for members of the National Guard who do not comply with the Department of Defense COVID-19 vaccination requirements. And then this statement: no credit or excused absence shall be afforded to members who do not participate in drills, training, or other duty due to failure to be fully vaccinated against COVID-19. What does this mean in real life? Well, in real life, it means as of tomorrow, members of the Air National Guard, not the Army National Guard, they have 6 more months plus. But members of the Air National Guard, as of tomorrow, even if they're not on federal duty, will no longer be paid, no longer be allowed to drill. That means this coming weekend, Air National Guard members that were headed to drill that have not been vaccinated can't drill. What does that mean in real life? Well, National Guard members don't get TRICARE taken and get that free and taken care of and provided for by the taxpayers like active duty does. To get TRICARE from them, it comes out of their check. But if they're not getting a check, then it interrupts their payments. So what the Secretary of Defense did yesterday was announce that Air National Guard members, as of this weekend, will not be paid anymore, will not be allowed to drill anymore, and we have thousands of them all over the country. At the last check, the Guard had about 50% compliance on the vaccination. In some areas of the Guard, they've had very serious concerns. Well, let me just identify this, not just as a readiness issue, that we have individuals that have served in the Guard for years that now are suddenly not going to be paid and are going to have their insurance at risk. And it's not just that, but this is also a federalism issue. And I know this gets lost in the conversation. The National Guard is not active duty. They're not reservists. The National Guard, when they're under Title 32, they actually work for the state. The National Guard in my state works for the governor of my state. The governor of my state is their commander-in-chief. According to the United States Constitution, for the Guard members, their officers are selected by the governor of the state. That's how we set up the National Guard. It's not the active duty. It's not the reserves. They're different. Their time when they're federally connected is when they're called up what's called Title 10. And the United States president actually calls them up, and they shift from Title 32 under the state's authority to Title 10. You want to know what the separations are, even in funding? Let me make it clear. The way the statute actually lays this out in Title 32, Section 108, if there's a Guard unit that's not complying, then DOD can cut funding to the state, not to individual members. What is this memorandum? It's not cutting funding to the state, it's cutting funding to individuals that are within the Guard. That is not allowed in Title 32, Section 108. The consequences for a Guard unit not being ready is to cut off funding to the state. That's how the section worked. In fact, even just a few years ago, in an NDAA, just like what we're debating, there was a section to allow the DOD to be able to reach into units and to be able to take on and punish individuals with their pay, and that was blocked here in this body, was not allowed. But this administration is going around Congress, around the states, reaching into individual airmen and docking their pay. And so far, this body is letting them. That is a terrible precedent. That is terrible for the families in this National Guard unit. It is terrible for the morale even because the Pentagon gave one set of rules to the Army Guard and another set of rules to the Air Guard. And these individuals, as of this weekend, will not be paid anymore unless this body acts. So my request is very straightforward. The amendment that I bring to the floor protects National Guard not just in my state, all over the entire country, because there are Air Guard members in every one of our states that are worried about what's going to happen tomorrow to them when they have been faithfully serving their country. And all that I ask is we file this simple amendment, we allow a vote on this simple amendment in this body, and we prohibit the discharging or the withholding of pay and benefits to National Guard members based on their COVID-19 vaccination status. It's very straightforward, it's very clean. It does nothing but say we stand with our National Guard members and we will not allow their pay to be cut, not only because we stand with them individually, but we also disagree with the interpretation of the Pentagon, who is not allowed to reach into a unit, select individual members and not pay them. That's not the way that it works under Title 32, Section 108. So yes, I asked to modify the request to include my amendment 4863.
Is there objection to the modification?
Madam President, I object to the modification.
Objection is heard. Is there objection to the original request?
Madam President,
The senior senator from Florida.
reserving the right to object. So let me explain what's going to happen here in a second. So we've all heard the stories, right? In China, in the Xinjiang province, Uyghur Muslims are taken from their homes, from their families. They're forced to work in these factories as slaves. They're forced to renounce their religion, change their name, forced sterilization, forced abortions. It's been characterized, rightfully so, as genocide. So I filed a bill, bipartisan support, and this bill says that any product that's made in a factory in that part of China, it has a presumption that it's made by slaves. And it passed the Senate unanimously. It's sitting over in the House. So I'm trying to get it here as an amendment on this bill. And here's what happens. The House, they have this thing where they come forward and say, under the Constitution, if it generates any revenue, it has to start in the House. The problem I have with that is that they interpret it very differently than how the Supreme Court has interpreted that clause in the Constitution. Very broadly. In fact, so broadly that they can basically use it on virtually anything. They can just apply it to anything they don't like. And so this is really not about revenue generating. The CBO said it's insignificant, really. This is about the fact that they don't want this bill to pass over in the House. And I understand why. Listen, there's some big companies out there, some very big companies. We know that for a time, Apple and Nike, a lot of big companies are pushing against it. They're not going to admit it. Who's going to go out and lobbying in favor of slave labor? But this is their bottom line. They make a lot of money by making stuff by people that aren't paid to make it. And they're lobbying against this thing. And I'm sure they've got rationale for it that they've given people. The bottom line is the House doesn't want to pass this, or at least some people over there don't. And the reason why I know that is because we passed it here unanimously. We sent it over there. And if this was, let me tell you what, if this was a revenue issue, if this was the issue was we're in favor of the policy, you're right, there shouldn't be slave labor and we shouldn't be participating in it. But we can't do it in this bill because it impedes on our prerogative as the House. If that was really their position, it'd be very simple. You pass our version, take the House version, pass a House version of our bill and send it over here and it becomes the law. Why haven't they done that? Let it originate over there and send it here. They haven't offered to do that. They don't. You know why they haven't done it? Because they're not for this. They're not for it. And they wield this blue slip thing to mean whatever they want it to mean. I support many of, not all of these amendments on here. Some of them have bigger revenue implications, but apparently those don't have blue slip because they're for it. The blue slip cannot mean it applies when I'm it applies when I'm not for the policy, and it doesn't apply when I'm for it. That's the bottom line. That's the way to answer. So I'm going to renew what I did here a few days ago, and that is I'm going to ask to modify the request to include my amendment, which is the body of this bill that every member of the Senate's already voted for, amendment number 4330.
Is there objection to the modification?
Madam President, reserving my right to object, the Senator from Florida is right. The key issue here is the blue slip, which originates from the constitutional language mandating that all revenue bills must begin in the House of Representatives. If it is determined by the House that it is a revenue bill, then anyone, I am informed, in the House can object, not just to the amendment of the gentleman from Florida, but to the entire bill. And essentially, if we pursued this, we would put at risk the entire National Defense Authorization Act for reasons that could be related to the issue that Senator Flower brings up, but it could be related to many other issues. And there are quite a few issues in this bill. And so for that reason, Madam President, I would object to the modification.
Objection is heard.